Okay, so welcome to this lecture, which is the fourth lecture on what Kelsen and Schmidt have to say about constitutional guardianship. And in this lecture, after we've looked at both Kelsen's and Schmidt's theories of the constitution and of democracy, I want to focus on the Kelsen-Schmidt debate in the narrow sense. So there was an exchange between these two authors about the question who ought to be the guardian of the Constitution in the late 1920s and early 1930s. And what we're trying to do today is to look at this exchange of arguments and perhaps to come to a conclusion as to who of the two had a more plausible case for their own conception of constitutional guardianship. So this will fall into three different parts. So first of all, we're going to look at Hans Kelsen's argument for constitutional review. The text that we are going to discuss is called On the Nature and Development of Constitutional Adjudication. So this was a presentation, a talk that Kelsen gave in 1928, I think at the annual meeting of the teachers of public law in Germany, who had an association that organized a conference every year. And in this lecture, Kelsen presented his case for the creation of a constitutional court in Weimar, Germany. So the background to this is that at the time in Austria, and remember Kelsen was Austrian, there was already a constitutional court. And in fact, Kelsen was a judge on that constitutional court when he gave that presentation. There was a debate in Weimar, Germany about whether a constitutional court should likewise be created in the Weimar Republic. And you can see Kelsen's argument here as a plea for doing that. So we'll go through the argument that's offered in that text. And then the second step is we'll look at Schmidt's book on the guardian of the Constitution, which aims to rebut the claim that the Constitution can be guarded or ought to be guarded by a constitutional court. And then we'll have a quick glance finally at the reply that Kelsen gave in his text, who ought to be the guardian of the Constitution, to the critique that Schmidt had made of his view. So let me begin then by giving a very brief overview of Kelsen's key argument for constitutional review. And so perhaps it's useful to say that Kelsen's argument intervenes in a particular situation. So the situation in the Weimar Republic is that there is a written constitution. So there is a constitutional document that contains a number of constitutional norms that are shielded from repeal or from being changed or amended in any way by ordinary legislation through an amendment rule that required a 2/3 majority for the change of the constitution. So you are in a situation where there is a written constitution, a formal constitution that does impose certain procedural, but also certain material requirements on the validity of legislation. So the Constitution had a Bill of Rights, of course, and it was expected that legislation was to conform to it. However, there was not any system of constitutional review in place. So there were no guarantees of the legality of the acts of those organs of state that exercise powers conferred by the Constitution. And so Kelsen's argument addresses this particular situation. You have a written constitution, but you don't have a constitutional court. And his claim is that if you find yourself in that situation, you ought to introduce a constitutional court, given that you are committed to the constitutionality of the acts of all the organs that exercise powers conferred by the Constitution. So what would be the point of having a constitution if it is not enforced against the organs that exercise powers provided or conferred by it? So we don't have a constitutional court. The Constitution will remain a dead letter or a lex imperfecta. And that is the core argument, the key argument that Kelsen presents for why a constitutional court ought to be created. So there are two ancillary arguments that I'm going to discuss as well, though only briefly. The first of these is that the Weimar Republic, like the Austrian Republic at the time, is a federal state. And there's a claim that a federal state requires a formal constitution that delimits the powers, the competences of the states and the federal government. But this division of powers must also be policed or must be enforced by a constitutional court, because otherwise, in any conflict, one of the parties, likely the federal government, would be a judge in its own case. So a federal state requires a judicially enforced constitution. And of course, there's also an argument that constitutional review is conducive to the functioning of democracy. Okay? But these are ancillary arguments. The key argument is the argument that without constitutional review, the Constitution will remain a dead letter. Now let me take a slight detour to exonerate Kelsen from a charge that is sometimes made against his argument for constitutional review. So some authors, for instance, Michel Troupert, the French legal theorist, has made this argument. They claim that Kelsen's argument for judicial review is just a rehash or a version of the argument for constitutional review that was made in 1803 by the Chief Justice of the US Supreme Court, John Marshall, in a case that's called Marbury versus Madison. And so in that case, the power of the US Supreme Court to exercise constitutional review was established by judicial fiat, if you want to put it that way, because the constitutional text itself does not explicitly confer on the Supreme Court a power to annul statutory norms enacted by Congress. And so in this case, you find the following argument made by John Marshall. He says, "It is a proposition that is too plain to be contested, proposition that's perfectly evident, that either the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act." So between these two alternatives, he says, there is no middle ground. Either the Constitution is superior or paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, it's alterable when the legislature is pleased to alter it. Then he goes on, if the former part of the alternative is true, then a legislative act contrary to the Constitution is not law. It's null and void because it violates a constitutional provision. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable. And what he concludes, of course, from this reflection is that it is appropriate for the Supreme Court to assume the power, to claim the power to declare statutes that are in violation of the Constitution to be not law, as he puts it here, okay? To annul them. So the problem with this as an argument for constitutional review is that it seems to be fallacious or unsound as an argument for constitutional review. Okay? So the reason is simple. So suppose it was true that any statute or purported statute enacted by a legislator that conflicts with the Constitution in any way is not law. It's null and void because it violates the Constitution. If that was the case, you might ask, why would it even be necessary for there to be a constitutional court that decides that a certain statute is in violation of the Constitution and therefore is to be annulled? So if an unconstitutional statute is null and void, then every citizen presumably should have the prerogative to disregard that law because it is in violation of the Constitution. And a judicial decision doesn't seem to be needed. Okay? So how do we get from here to a power on the part of the court to annul laws? So to approach this in a slightly different way, you can observe that when there is disagreement about whether some statute that's been enacted by Congress is constitutional or not, it will typically be the case that there is space for reasonable disagreement about the constitutionality of the statute. So even competent lawyers may disagree about whether some statute is constitutional or not, and arguments may be offered on either side, right? And it's because such reasonable disagreement is possible that an authoritative decision on whether the law is to be regarded as valid, taken by a constitutional court, is necessary to clarify the constitutional situation. Okay? But then, of course, you can raise the further question, well, why should it be a constitutional court that decides on the contested constitutionality of a statute that's been enacted by the legislature? Okay? So some authors, like Jeremy Waldron, whom we'll discuss tomorrow a little bit, say that, well, in a democracy, the legislature himself, or herself, itself, perhaps I should say, should decide on the constitutionality of statutes. So judges have no special powers of insight compared to legislators or other citizens. In a democracy, the legislature's judgment of constitutionality should be determined. So you can make this argument, of course, and the considerations that Marshall offers here, they do not show that this alternative is to be rejected. Okay? So for these reasons, people often claim that Marshall's argument is problematic. You cannot infer from the claim that the Constitution is paramount law, that a constitutional tribunal ought to have the power to annul statutes enacted by a legislature. Now, what I want to emphasize here is that Kelsen does not make this argument. So he does not say that because the Constitution claims to be paramount law, we can infer straight away that a constitutional court, or that, well, perhaps I should say, we can't straight away infer that a Supreme Court can assume the powers of a constitutional court. So Kelsen's argument is an argument about constitutional reform. So what he's trying to show is that if you have a formal constitution, then it is useful in order to make the constitution legally effective to change the constitution in such a way that a constitutional tribunal endowed with the power to annul statutes is introduced or written into the Constitution. Okay? So he's not arguing that the mere fact that there is a constitution empowers courts to exercise constitutional review. It's an argument de lege ferenda, if you want to put it that way. Good. Now, to understand Kelsen's argument, we have to delve a little bit into Kelsen's legal theory, the pure theory of law, and look at some key ideas in that theory. And I assume that most of you will be quite familiar with this. So the key idea that Kelsen works with in his argument for constitutional review is the claim that, at least from a dynamic perspective, a legal system forms a hierarchy of different norms. So here there's a simple presentation of that hierarchy on the slide. The topmost level of the legal hierarchy is the infamous basic norm. It's the assumption that all law created in accordance with the first constitution is legally valid or legally binding. And the basic norm authorizes or makes normative constitutional norms as the next level of hierarchy. And then we find below the level of constitutional norms, statutory norms, then administrative decrees, and finally particular judicial or administrative decisions. Good. And so the basic idea, of course, as you are well aware, is that when we move down the hierarchy, the norms that you find on some level, for example, statutory norms, are norms the creation of which is authorized or empowered by the norms that you find at the level right above. So the enactment of statutory norms is authorized and enabled by constitutional norms that prescribe how statutory norms are to be made, what procedures are to be used for their enactment. And of course, it may also be the case that apart from providing procedures for the enactment of statutory norms, constitutional norms will also put limitations on the permissible content of a statutory norm. So for instance, where a constitution contains a Bill of Rights. Good. Now, a further point that's important here is that moving down this hierarchy of norms, when new norms are created on lower levels of the legal hierarchy, the norms that you find at the higher level, while they authorize the creation of lower level norms, and while they may impose certain restrictions on the permissible content of lower level norms, they never completely determine the content of lower level norms. So any enactment of norms on a lower level by some organ empowered to exercise legislative powers is always partly discretionary. Okay? So the easiest way to explain that is, again, to focus on the relationship between constitutional norms and statutory norms. So the Constitution empowers a legislator to make laws. Perhaps it imposes certain limits on what laws can be made, but within those limits and using the authorization given by the Constitution, the legislator has a free choice between a wide range of different possible pieces of legislation that the legislature could decide to enact. And the idea is that a statutory norm will be valid if it finds itself within the limits or the frame of discretion that is set by constitutional norm. And so the idea is that a similar two-sidedness that combines authorization and limitation on the one hand with discretion on the other is found on lower levels of the legal hierarchy. So suppose, for instance, that a judge takes a decision in a particular case that appeals to a statutory norm. So in that case, Kelsen thinks it will still be possible for a judge usually to choose between a number of different decisions that are permitted by or authorized by the statutory norm. It is only that the freedom to decide has been narrowed down in comparison to the freedom that is enjoyed by a legislator who implements or who applies constitutional norms. So on all levels of this hierarchy, you have in acts of enactment this dual character of applying the law, but also creating new law in the process of applying law on higher levels of legal hierarchy. And one important implication of this is that there is no hard and fast distinction, Kelsen argues, between legal and political decisions. And that is going to be a key point in his dispute with Schmidt. So any act or any decision that creates a legal norm is always partly discretionary, even though it is authorized by higher level legal norms. And that means that it's impossible, even if you look at a judicial decision in a particular case, to draw a sharp distinction between applying the law and legislating. So every legal decision taker always does both in taking a legal decision. Good. So constitutional guardianship then. What does constitutional guardianship aim to achieve? Well, I guess the aim of constitutional guardianship is to make sure that when norms are enacted that are located at the level below constitutional norms, so for instance, when statutory norms are created by a legislator, the problem here is to ensure that these statutory norms conform to the limits of permissible legislation that are set by constitutional norms. And so Kelsen's question is, how can we guarantee, or how can we ensure, how can we make it the case that statutory norms or other enactments that are taken in exercise of powers directly conferred by the Constitution comply with the limits set by constitutional norms. Oh, so I'm sorry, so this slide doesn't display 100%, but I'll try to talk us through it. So the question that we should raise now is, well, suppose you have this wonderful legal hierarchy where constitutional norms are supposed to set limits for the enactment of statutory norms. What happens if the legislator, say, who's empowered to enact statutory norms by the Constitution, takes a decision that perhaps in our view violates or doesn't conform to the strictures, the limits imposed on legislation by constitutional norms? Okay? And so you can think of a number of different responses to this question. So one of these I have already talked about a little bit in discussing Marshall. So someone might say that, well, if there is a statutory norm that violates the Constitution, that is made, for instance, in violation of a constitutional right, then because the Constitution is paramount law, because it sets the conditions of legislative authority, that statutory norm is null and void. Okay? It's not a law, as Marshall put it. And if it's not a law, then, well, it doesn't bind anyone. So every addressee of the law, every ordinary citizen might be entitled in that case just to disregard that enactment due to its unconstitutionality. Okay? And so Kelsen does argue that there may be cases in which you encounter this phenomenon of absolute nullity of a legal enactment. So the example that he gives of that typically is the example of the Hauptmann von Köpenick, who is displayed in the picture on the slide. So apparently at some point in the later 19th century in Wilhelmine, Germany, there was a man who was actually a tailor by profession and who was not a bearer in any way of any public powers, who put on the uniform of a Hauptmann. I think that's a captain or a colonel, so a military officer. And with this uniform, he went to the town hall of the town of Köpenick, which is sort of a small town close to Berlin, and he told the people in the town hall to hand over the money that they had in their chest, okay? Claiming that he was the bearer of an official order that they ought to give that money to some other institution. And lo and behold, he was obeyed. He received the money because people in Wilhelmine, Germany had an exaggerated respect, I guess, for military uniforms, and they did not question his credentials or his authority. Okay? But the claim here is, of course, if an imposter like this Hauptmann von Köpenick, if he appears and gives you a command that claims to have legal warrant, then that command is null and void, right? And you are entitled as a citizen to disregard it. But of course, if we took the first response to be the last word about how to deal with statutory enactments that we may deem to be unconstitutional, then a problem will very, very quickly arise. And that's a problem of anarchy, if you want to put it that way. So if every citizen was entitled to disregard any law made by a legislator or any directive issued by another public authority on the ground that they believe, the citizen personally, that the law or the mandate, the directive is unconstitutional or illegal, then of course legal order would very quickly break down, because people will feel entitled to disobey the law, one might expect, whenever they are faced with a legal directive that goes against their interest or their wishes. And of course, people will disagree all the time about whether some statute is constitutional or not, and the result will be anarchy, right? Legal order will break down. So this first response cannot be the last word about how to deal with constitutionally defective statutory norms. So there is a second way we might respond, and that is to say that whenever a norm is enacted by a public authority, so say a norm is made by Parliament, which we recognize to be a legitimate public organ, then that enactment enjoys a presumption of validity. Okay? So what this means is that the norm will be valid, right? No matter that perhaps there may be good reasons, convincing reasons to think that in its content, the norm in question, the law that has been made by the legislator, conflicts with a constitutional provision, right? Because we presume that all pieces of legislation enacted by our legislator are valid. Your own private worries about the constitutionality of the act must be set aside, okay? And of course, this response alleviates or mitigates the problem of anarchy that we might run into if we adopt the first response, right? So if everyone is bound or obligated to regard all laws as valid that are coming forth from our officially recognized legislator, then presumably there will be legal order and people will be bound to recognize as law whatever is put forward. But the drawback, of course, is that we now lack any assurance that the laws that are made by our legislator show material conformity with constitutional norms, right? So it seems now we are stuck in a situation where our legislator can legislate in any way they please, as long as they go through certain procedural steps that ensure that we can recognize what they do as an act of legislation, and then the law will be binding, right? No matter whether its content conforms to the limits set by the Constitution or not. And that is also not an attractive option, right? This is the situation where the Constitution itself remains a dead letter or a lex imperfecta, because as a matter of fact, the legislator, as long as they jump through the requisite procedural hoops, can legislate in any way they want. Okay? Now, again, remember that Kelsen speaks to a situation where there is a written constitution that purports to impose limitations on the permissible content of legislation. So what would be the point of having such a written constitution if you stay in this condition here where the legislator, in effect, is free to disregard constitutional limits? So you must take a further step. You must introduce guarantees of the constitutional legality of enactments. And so how do you do that? Well, you hold on to the presumption of constitutionality, but you don't say that any law made by the legislator is valid. What you say is that it's provisionally valid. It's voidable. So someone who thinks that the law is unconstitutional, of course, can challenge it in some legal procedure, that is the idea, in front of a constitutional tribunal. And this constitutional tribunal will have the power to annul the norm, to strip it of its validity, if it judges that the norm in question is unconstitutional. Okay? And so Kelsen's argument again is to say that this is the option we should embrace, because what it gives us is both a protection against the anarchy that results from the view that everyone is his own judge of the constitutionality of laws and other directives, but it also frees us from the potential oppression of a legislator whose enactments might make the Constitution empty and unable to protect our rights. So we need to accept that laws made by a legislator who's officially empowered by the Constitution are to be recognized as valid in the first instance, but there must be a way to challenge them. There must be an institution that can remove them if indeed it is judged that they are unconstitutional. So to do that, of course, what we need to do in the context of Weimar Germany is to introduce a constitutional court empowered to annul unconstitutional statutory norms or decrees. Good. Now, the general idea, as I said, is that the Constitution is not to remain a lex imperfecta. So in the article or in the presentation that I'm talking about, so Kelsen considers the possibility that there might be guarantees of the constitutionality of statutory norms other than a constitutional tribunal empowered to annul unconstitutional norms. So for instance, you might think of a provision that requires members of government to sign pieces of legislation and to vouch for their constitutionality, and then to make them personally liable for the enactment of unconstitutional acts. But Kelsen observes that historical experience of the use of such guarantees of legality has shown that they are ineffective, and he thinks that the only proper way to guarantee the constitutionality of statutory norms is to create a constitutional tribunal endowed with an explicit power to annul unconstitutional norms. So that is how we arrive at the conclusion that constitutional review is required for the Constitution to become legally effective. Good. Now, though Kelsen mentions these ancillary arguments, he doesn't really rely on them very much in his paper on constitutional review. So I guess so far, the argument that's been presented would apply perhaps to any state, to any constitutional system where there are constitutional norms that purport to govern or to limit the range of permissible statutory enactments. However, there is I guess, a link or a closer kinship between constitutional review or the demand for constitutional review and certain types of constitutional framework. And so the first claim that's relevant here is that Kelsen argues, as I explained already, that a federal state requires a formal constitution enforced by a constitutional court. So perhaps as a historical point, it could be mentioned that Kelsen, who was an Austrian, of course, thought about constitutional review in part in the late 19th, early 20th century because he was interested in the constitutional structure of the Austro-Hungarian monarchy, which was a federal state. And many arguments for constitutional review were offered even in the late 19th century in that context. So thinking about the structure of a federal state is historically the origin of demands for constitutional review. Now, the second point, of course, and this takes us back to yesterday's lecture, is that a constitutional court may be needed, or it may at least be helpful to protect the fairness, the openness, and the inclusive character of democratic political competition, which is at the core of the legitimacy, as we've seen yesterday, of a democratic constitution. And as we mentioned yesterday as well, Kelsen claims that a constitution, at least in a state that contains ethnic, linguistic, religious minorities, may be needed to protect the rights of these minorities against majoritarian oppression. And of course, in situations where such rights are needed, there must also be a court that can enforce them. And this is a further argument for the claim that a constitutional tribunal ought to be introduced in the Weimar Republic. Good. Now, yesterday we already broached the question whether Kelsen's defense of constitutional review is compatible with his understanding of democracy. And so you recall that Kelsen's understanding of democracy is centered on the idea that a democracy is a state where laws are made by the majority of the people, or by the majority of the representatives of the people. And he thinks that the virtue of this form of decision-taking is that it maximizes the freedom, the liberty that people can enjoy while being subject to the law. Okay? So the promise is that though not everyone will be free under democratically elected law, at least a majority of people will be free. Now, if you introduce a formal constitution that imposes limitations on on the permissible content of legislation. And if you enforce those limitations with a constitutional tribunal, it seems you run the risk that the constitutional tribunal may take decisions which are rejected by a majority of voters, or perhaps a majority of members of parliament. So a decision to annul a certain statutory norm enacted by a parliament may be counter-majoritarian. And in that case, the legal situation may move away from being maximally liberty-preserving. So it seems that you would have to stick to the majority rule to hold up the promise that democracy will make as many people as possible free. So there seems to be a clear tension here. What does Kelsen have to say about how the tension is to be mitigated? I should say, perhaps before I go through the points, that this is a weak point in Kelsen's argument. So I'm not sure he has a really good way of handling this point. But let me present to you what he has to say about it. So one claim that Kelsen makes is that if a statutory norm is annulled by a constitutional court, we should be happy to concede, or the proponent of constitutional review should admit that this is an act of legislation. So to annul a law is an act of legislation as much as to make a law. However, Kelsen says this is an act of negative legislation only. So I guess what he wants to say by that is simply that a constitutional court cannot enact a law. It can only take down the law that has been enacted by the legislature. And the claim is that though this power of negative legislation is a legislative power, and though someone may think that for a court to exercise legislative power violates the separation of powers that maintains a democracy, since it is only a form of negative legislation, this power is less troubling from a democratic point of view than we might think at first glance. So make of that what you will. I don't think this argument is particularly impressive or cogent as a way to trying to mitigate the worry that constitutional review may have or may come to stand in tension with democracy. Now, there are a number of further remarks that Kelsen makes in his presentation, which are meant to at least to mitigate or to soften the conflict between democracy and constitutional review. So one of the claims he makes is that a lot depends for whether there is a conflict between constitutional review and democracy. A lot depends on what your constitution is like. So what the content of your written constitution turns out to be. And Kelsen argues very strenuously that a good written constitution should be predominantly technical and procedural. So it should refrain from including vague general principles or moral proclamations which would have to be interpreted and applied by a constitutional court in its operative provisions. So the idea is that if you have a constitution that is laden with such general principles or moral proclamations, this will empower courts to decide in ways that might turn out very strongly counter-majoritarian. So it is better to keep such provisions to a minimum in drafting a constitution that's to work in a democracy. And as far as the behavior of judges is concerned, of course, Kelsen argues that judges ought to adopt a narrow approach to enforcing constitutional norms. They should not adjudicate on the basis of what they take to be the spirit of the Constitution. And the idea is that if judges adjudicated in that way, and perhaps if they were encouraged to do so by the content of the Constitution, then there is a danger that over time their decisions will restrict more and more the openness of the democratic process, which, as I argued yesterday, is necessary for people who are outvoted at the present point to have the hope that they may be members of a majority at some point in the future. So these suggestions are not really a tidy solution to the counter-majoritarian difficulty. But I think what Kelsen would argue is that it's possible for a constitution to be written in such a way and for judges to restrain themselves to the extent that the conflict between democracy, the potential conflict between democracy and constitutional review, does not become an actual conflict. And that is what, obviously, he recommends we should strive for. Good. So that was a rundown, a brief presentation of Kelsen's argument for judicial review. So let's turn to Schmidt. And I think in talking about Schmidt, we can be somewhat briefer, because though his book on the Guardian of the Constitution is quite a long and sprawling piece, the basic ideas in it are very few and very simple, not to say simplistic. And I think Kelsen was quite right to see them as unconvincing. So let me try to give you the core argument in Schmidt's book on the Guardian of the Constitution, the core argument against the claim that a constitutional court ought to be created in Weimar Germany. And so the argument starts out from what I call here the model of subsumption. So the model of subsumption is an account of how Schmidt thinks judicial decision-taking works, or at least an account of how he thinks it should work, or must work if we are to consider it to be legitimate or authentic judicial decision-taking. And so the idea here is simple. The claim is that what judges can do, taking a judicial decision, is nothing more than to subsume some fact pattern under a legal norm, and then to draw the conclusion that is prescribed by the legal norm. Okay? So you might think of a rule of the criminal law that determines that if someone commits a certain type of act, then they are punished with a certain prescribed sanction or punishment, right? And the idea is that all that judges can legitimately do is to look at such statutory norms, to compare them to fact patterns, and then if the fact pattern matches the condition given by the legal norm for the application of some consequence, to apply that consequence. So the model of subsumption, in other words, is the model of judicial decision-taking that we've encountered yesterday in looking at statutory positivism and the satirical description of statutory positivism given by Hermann Kantorowicz. Okay, so the judge as an automaton that just follows some algorithm provided by statutory norms. Good. And so the claim is that this is what a true judicial decision is. It's a simple act of subsumption. Now, the second observation that Schmidt makes is that, well, suppose there were a constitutional court. So cases that might come to such a court will always be cases in which there are doubts and disagreements, as he puts it, over the meaning, over how to understand some constitutional norm. Okay? But of course, if there are doubts and disagreements about how to understand some constitutional norm, then a constitutional tribunal that was to decide a case would have to do more than just to subsume. It would have to resolve the doubts and disagreements about the meaning of the constitutional provision that is at issue. But to do so, Schmidt claims, is not true adjudication. So to authoritatively resolve doubts about the meaning of a constitutional provision is an act of legislation, okay, as opposed to mere subsumption. And therefore, it is not a true judicial decision, and hence should not be assigned to a court. So there's a third idea, which is related to the other two, which is to say that one cannot make a decision judicial simply by assigning it to a court. Okay, so the idea is that there's something like a nature or a true character, an essence of a judicial decision, and that is to do nothing more than to subsume under a legal norm. Right? That is what a judicial decision is. Now, of course, you could assign the responsibility for resolving doubts and disagreements about the content of a constitutional provision to an institution that you call the Constitutional Court. Okay? That's possible, obviously, but if you did that, you would not thereby make the decisions that this tribunal would have to take judicial decisions. Because a true judicial decision does nothing more than to subsume under a legal norm. Okay? So therefore, your institutional design should be arranged in accordance with the true nature of a judicial decision. That is, courts should be given the power only to apply legal norms, but not to resolve doubts and disagreements about their content. Good. So that is Schmidt's key argument against constitutional review exercised by a court. Now, I suppose there are two questions that that immediately arise, I think, or two obvious objections to this fairly simplistic argument. So one question that you might have, because I talked so much about Schmidt's early work, Statute and Judgment, in the second lecture, is whether the narrow account of adjudication that Schmidt gives in his book on the Guardian of the Constitution is even compatible with what he says himself in his early work in Statute and Judgment. And you recall that what he argued in that work is that judges are not guided by statutory norms alone. They are also guided by implicit conventions of adjudicative practice, which are not contained either in the Constitution or in statutory law. So it seems that there is an obvious conflict or contradiction between the view of adjudication that he offers in 1931 in the Guardian of the Constitution and his earlier view. But perhaps the worry about this could be allayed by arguing that even in the early work in Statute and Judgment, Schmidt does hold on to a kind of formalism, as we have seen, because he thinks that understandings that are established in practice can make the application of statutory norms perfectly predictable or calculable. Okay? So perhaps there is a tension here, but it may be that Schmidt has a response to that objection. But the second objection, which we will see Kelsen make, is more difficult to get around, and that is to ask why we should accept Schmidt's claim that the activity of courts ought to be limited to subsumption. Okay? So of course, Schmidt claims, as we have seen, that the true nature of a judicial decision is that it is nothing more than an act of subsumption, right? But why should we accept this stipulation about the true nature of a judicial decision? Schmidt doesn't seem to offer us any argument to accept that all that judges or that courts can usefully do is to subsume mechanically under an existing norm. Right? So other than just to stipulate that the true nature of a judicial decision is simply to subsume, what other reason is there to accept this limitation on legitimate judicial activity? So here are a few considerations that Schmidt offers in response to this question. So first he says that to create a constitutional court, to make it responsible for resolving doubts and disagreements about the meaning of constitutional provisions, would overburden that court, that you make a constitutional court, and it would undermine the rationale for judicial independence. So the claim here is simply that courts cannot legitimately take legislative decisions. So if you assign to them the responsibility to take such decisions, what happens is just that people will come to question the legitimacy of the court once they disagree with the content of the political decision it has taken. And of course, if people come to question the decisions taken by courts for such reasons, then they may also come to question the rationale of the independence of the judiciary. So Schmidt thinks that a court can legitimately claim independence only if it limits itself to the activity of subsumption. Now, he also argues, of course, that, as we have seen yesterday, if a court was to take legislative decisions that determine the meaning of constitutional provisions, then of course it would interfere with the democratic process. So we've seen that Kelsen acknowledges that worry and tries to respond to it. And finally, Schmitt tries to brush off the obvious observation that in 1931 that there are already courts that act as constitutional tribunals. So for instance, the Austrian Constitutional Court, but also, of course, the US Supreme Court. So Schmitt doesn't say anything about the Austrian example, but what he says about the US Supreme Court is that it operates in a completely different society that is committed as its own concrete order to a liberal social setup. And in that context, he says, a constitutional court might operate as a guardian of a liberal social structure. But German society or European societies do not carry this commitment to liberalism in the same way, and therefore the American example is irrelevant in the German context. Good. So this is Schmitt's argument against a constitutional court. So he also has a further argument for executive guardianship, of course. So the claim is that it's unnecessary for us to introduce a constitutional court as a guardian of the Constitution because there is already a guardian of the Constitution provided by or authorized by the Weimar Constitution. And of course, that is the president acting, as we have discussed in the first lecture, under Article 48 of the Constitution that confers a power of dictatorship. So the claim is that the Weimar Constitution elevates the president by endowing him with these special powers into the position of a neutral power, a pouvoir neutre. So it's an idea that Schmitt borrows from Benjamin Constant. So the Constitution puts the president as a neutral power above party politics with the intention to allow him to intervene if the functioning of the constitutional system is threatened. And the president is not just given these powers by the Constitution, he also has democratic legitimacy because he is directly elected by the people. Now, Schmitt adopts here the terminology of a neutral power to describe the powers of the president, but he is quite careful to define this idea of neutrality in a particular way. So the president is not to be politically neutral. He's not supposed to be politically neutral towards those who may be a threat to the Constitution. So the idea of neutrality here is to be understood as a claim to the representation of the people as a whole, which stems from the fact that the president is elected directly by the people as a whole. So his neutrality consists in standing above particular political parties, but he is a partisan, and he's supposed to be a partisan of the identity, the content of the Constitution that he is called upon to defend. Okay. So, of course, this argument for presidential guardianship takes Schmitt's discussion in a direction that it seems to lead him to understand the idea of constitutional guardianship in a different way than Kelsen understands. Okay? So Kelsen understands the task of constitutional guardianship as the task to offer guarantees for the constitutionality of statutory norms or other enactments, decrees that are enacted directly under powers conferred by the Constitution. So the problem of guardianship is a legal problem or a problem of making constitutional law effective. So Schmitt has a different understanding of the task of guardianship. He's not focused on compliance with constitutional law, but he's concerned rather to protect the political unity of the state and the social conditions of normality and homogeneity that, in Schmitt's view, as we have seen, are conditions of the applicability of law. Okay. And this raises the question that we'll take up in a minute, of course, of whether Kelsen and Schmitt might just be talking past each other in discussing this problem of constitutional guardian. But before we get to that, let me just very quickly give you Kelsen's reply to Schmitt in a very, very lengthy and very acerbic review of Schmitt's book, The Guardian of the Constitution. It's called Who Ought to Be the Guardian of the Constitution. So if you want to read a very, very nasty and brutal takedown, it's fun to look at this, but I'm going to condense it into very few points. So the first point is obvious. So Schmitt works with the model of subsumption, as we've seen. So the claim that a true judicial decision does nothing more than to mechanically apply a statutory norm. And so Kelsen points out, and obviously he must be right to make this claim, he points out that this model is much too narrow to understand what happens even in the ordinary process of adjudication, not to mention the process of constitutional adjudication. So even if you look at cases in civil law or criminal law, ordinary cases of no great political significance, you will see, of course, that judges, competent jurists disagree all the time about how certain legal provisions are to be understood and applied. So judges must, in order to do their job, in order to resolve legal disputes, very often go beyond the activity of mere subsumption. If this is true in the law in general, then of course Schmitt's argument doesn't provide us a reason for thinking that we shouldn't accept judges doing more than to subsume in the context of constitutional adjudication. So of course what's behind Schmitt's model of subsumption is the idea that we should try to draw a very, very sharp distinction between legal and political decisions and argue that judges can never be empowered or authorized to take political decisions. But this view, of course, is a view that you will reject if you are a proponent of or an adherent of the pure theory of law and its conception of legal hierarchy. Because what the model of legal hierarchy shows, assuming it is correct, is that whenever legal decisions are taken, the decision in question is partly discretionary, partly political. So that is true, then of course the claim that decisions that would have to be taken by a constitutional tribunal would be political, that objection falls away. It doesn't make any sense. It betrays a misunderstanding of how the law operates. Now the third reply is that Schmitt's claim that a true judicial decision does nothing more than to subsume is just a stipulation. And Kelsen calls this Begriffsjurisprudence, or conceptual jurisprudence. So Schmitt just defined the concept of a judicial decision in some arbitrary way, and then tries to draw normative conclusions from that stipulation. And that, of course, is an unsound method of argument. So the real question is, and this is a pragmatic question, whether it is politically useful or appropriate in a democratic constitution to assign the power to resolve constitutional disputes to a court rather than to an executive agency like the president. And Kelsen thinks that there are a number of pragmatic arguments for thinking that it would be appropriate, useful, to assign the power to resolve constitutional disputes to a court rather than to a political organ of the Constitution. And so one of these is that we are all convinced, or we all agree as good lawyers, with the maxim that no one should be a judge in his own case, nemo judex in causa sua. In order for the resolution of a dispute to be non-arbitrary, to be neutral, to be fair, the decision about how to resolve a dispute between two parties must be taken by a third party that is neutral between the two. Now, suppose that you have a constitution and different constitutional organs end up in conflict. So you might have a conflict between the president and the parliament, or between the federal government and the government of a state. If you want to resolve these disputes in a way that doesn't make one of the parties a judge in its own case, then what you have to do is to create a constitutional tribunal. So perhaps there is a sense in which the decisions it would take would be political, at least in part, but the tribunal would at least be neutral between the contesting parties, and that speaks for introducing a constitutional court. Now, how good this argument is perhaps a question that you might think about, because obviously the assumption here seems to be that a constitutional tribunal will never itself become a party in a constitutional conflict. And perhaps that assumption is not as warranted as Kelsen thought it to be. Now, there's a second pragmatic reason he offers. He says that, well, if a constitutional dispute is resolved in a trial, at least we will enjoy the advantage of seeing the case on both sides openly articulated in a public trial, the arguments presented to the public, and perhaps the need to do that will impose a certain discipline on the contestants or those who find themselves in a constitutional dispute, and encourage a degree of good faith and commitment to the Constitution in the contestants. And that again is something, in effect, that we should value and that Kelsen hopes will be brought about by assigning constitutional disputes to a constitutional court. Good. So this is the last slide for today, and it's really a bit of a transition to the last lecture tomorrow. So at the very, very end of his article, Who Ought to Be the Guardian of the Constitution, Kelsen seems to hold out a kind of olive branch to Schmitt, though he savages his argument against the constitutional court. And I think the olive branch goes back to an observation I made a few minutes ago, that it seems that Schmitt and Kelsen just operate with two different understandings of guardianship. So I think at the end of this article against Schmitt, Kelsen suggests that, well, perhaps we are just talking past each other. Perhaps we should just recognize that the notion of constitutional guardianship is ambiguous, and there are two different ways in which it could be understood. So one of these, of course, is to understand it from a legal perspective as the preservation of constitutional legality in the norm enactments that are undertaken pursuant to constitutional authorization. The second way we might think about constitutional guardianship is a political way. So we might think of guardianship as centered on the task of holding together the state, providing a fallback governance structure, perhaps securing public order in a situation of grave crisis. And so someone might argue, and perhaps Kelsen wishes to make that suggestion at least, that these two forms of guardianship need not be mutually exclusive. So perhaps it's possible in a constitutional system to provide both for legal guardianship, giving legal guarantees of the constitutionality of statutory norms, but to provide as well for a political guardianship that can take on the different tasks that Schmitt assigns to the president. Okay? And perhaps in that way, the two conceptions could be integrated into a combined understanding, a more holistic understanding of constitutional guardianship. And so in the lecture tomorrow, what I will do is to ask whether this form of combination makes any sense. And I will argue that it doesn't, that we have to choose either to focus on the legal conception of guardianship or the political conception of guardianship. Okay, so thank you very much. And I hope you have some questions.
I have two questions. One very crucial. Did the president in Weimar Republic should be affiliated to a party, or would we run for election without a party affiliation? Yeah. Because you said he is a politician, but it's above the parties. But he should be affiliated to some party to run for the elections. Yeah.
So there was no legal requirement for the president to be affiliated with any party. And as far as I know, the president, who was in charge at the time that this debate unrolled, so Hindenburg, he wasn't a member of any political party. However, of course, in the election in which he was elected, and he was re-elected once, Hindenburg was endorsed by some of the political parties, but not by others. So, for instance, I think the Center Party and also the Social Democratic Party advised its own members and voters to vote for Hindenburg. And some other parties, the National Socialist Party, for instance, or the Communist Party, ran their own candidates and did not tell their voters to vote for him. So in that sense, he wasn't a member of a party. He was elected directly by the people, but obviously his election was, to some extent, a result of the support that he had been given by some political parties. But he himself was unhappy to some extent about having been supported by the Social Democratic Party in particular, and therefore the president and the circles around him were very keen, and Schmidt, of course, is a case in point, to present the president as being untied from all party political power.
And my second question is related a little bit to Brazilian history and how we see this difference between Marshall and Kelsen, because the doubt is, does Kelsen offer some argument for having a specific constitutional court and not judicial review like we have in the United States, in which each judge must not apply an unconstitutional law to a complete case, and so the Supreme Court will take the far-reaching decisions. But since 1988, we have all this kind of abstract actions. So our Supreme Court is also a constitutional court. And my point is, does Kelsen offer some argument for having a constitutional court just deciding on constitutional questions against the argument of Marshall that the judge is applying law to the complete case and he must not apply an unconstitutional law? But he could not decide for every case. He would not annul or make the law valid for all the cases.
Mm-hmm. Yes, I think you can take an answer to this question from Kelsen if you read between the lines a little bit. And so I think that he would argue that to have a specialized constitutional tribunal has a number of practical advantages. And so one practical advantage is that constitutional disputes can be resolved quickly and expeditiously if there's a possibility for relevant parties to make direct appeal to a constitutional court when they believe that there is a problem of constitutionality in some statute or other norm authorized by the Constitution itself. And if they don't have to work their way, as in the US, through different stages of appeal before the case reaches the Supreme Court, when in many cases it may be too late really to remedy the problems that arise from an unconstitutional enactment. And so another, I guess, pragmatic or technical consideration that he endorses is the idea that to have a special constitutional court is useful because it leads to a unification of legal doctrine. So he discusses the possibility that you might have a system where every court is entitled to exercise a power of constitutional review and to disapply a norm that court holds to be unconstitutional. But the problem with that, of course, is that you would see different courts taking different decisions or conflicting decisions about the constitutionality of some statute, for instance. And to avoid that fracturing of the law, it is useful to have a centralized constitutional court.
But then you deny this power to all other judges.
Yes.
I have a few questions, but I'll try to pose them one by one. So my first question was that in your lecture, you said that Kelsen tries to solve the problem of anarchy by presenting the idea that against Marshall, in some sense, that the law that's put by authority is presumably legal until it's nullified by authority, of course. But isn't this solution also argumentatively weak? Because in order to respect the law presented by the authority, I must also make an assertion that someone is authority. So in some sense, that doesn't really solve the issue. It just pushes to another degree, so to speak. Am I right or no?
Yeah, I think in a sense you're right. Okay, so one could take a very, very radical line and say that some organ that is empowered by the Constitution to enact legal norms is acting in its official capacity only if it shows complete conformity with all the higher level legal norms that authorize but also condition its own legislative activity. Right? So you might say that whenever a legal mistake is made or a constitutional mistake is made, for example, the legislator is no longer the legislator. Okay, because to be the legislator or to act in that role requires perfect legality of the decisions that are taken. Yes, I mean, I think you could take that view, and perhaps that would be the most stringent or the most a coherent way to look at the issue. But Kelsen, again, so he thinks that this view would be impractical because there would be too much disagreement among the members of a society about whether constitutional norms have been violated for the legal order to remain operational, right? So what you have to do is to acknowledge that that organs that are designated by the Constitution and that operate in accordance with constitutional norms enjoy a presumption of validity. So that is the idea. But it does raise the problem exactly how much we want to demand of the legality of the institution's operation before we granted a presumption of constitutionality. So suppose that there is some minor procedural flaw in the legislative process in Parliament, for instance, right? So should we grant that law a presumption of validity, or should we say that, well, there was a procedural mistake, so this decision is not a decision taken by the legislature? And these are issues you could debate. So what are the minimum conditions for acknowledging that the presumption of validity applies? And I don't think Kelsen offers a clear and precise answer to that. And there's definitely room for disagreement here, right, among the members of a political community. And that may be a problem that could arise for his framework.
I think that it's solved a little, but Kelsen doesn't really solve the issue very much.
No, well, perhaps it can't really be solved theoretically, perhaps.
Just practical.
Yes.
So my second question is more historical in some sense, because Kelsen. No,
To speak to the masses.
Não sei se tá ligado. Não. Talvez não. So my second question is that Kelsen presents the Constitutional Court as a negative legislature, but this claim really depends on a constitution that doesn't grant rights. So the court will only preserve the legislative and constitutional process. But when Kelsen wrote this piece on the Constitutional Court, was this claim feasible? Because we had constitutions around the world that had a Bill of Rights. So France has Bill of Rights, the US has Bill of Rights. In Brazil, we had a Bill of Rights. So was it feasible, or really Kelsen trying to push some that only works theoretically?
Right. So I take it that what you're saying is that as soon as the court has to decide on how to apply constitutional rights, in effect, in striking down the law, offering an argument about a right, it will in effect legislate positively because it will set boundaries for all future acts of legislation. And it makes no sense to say that all that it is doing is to be a negative legislator in annulling a law that was made by Parliament. So perhaps that makes sense if we only look at procedural requirements, but not when we look at rights. Yeah. So I guess all I can say about that is that I find that compelling, and I think that's right. And as I indicated in the presentation, so it seems to me that this argument that a constitutional court would merely be a negative legislator, it seems to be a weak argument, and I don't think it helps Kelsen very much. So perhaps one further thing that might be said is that so part of what's going on here is that Kelsen tries to argue against a certain understanding of the separation of powers, which has it that courts can never legitimately legislate. Okay? And so I think perhaps the constructive aspect of this argument is that there's an admission here that a constitutional court would have to legislate, but because the distinction between applying the law and making the law is softened or undermined by the pure theory of law and by the model of legal hierarchy, the suggestion is we shouldn't be too worried about the court taking on a legislative role. And perhaps that is really what you can take from the argument, and the idea of negativity, I think it doesn't have that.
But I think that the individual rights can be enforced by the courts through individual remedies like freedom of expression, freedom of movement, without this power to make the legislation void. So courts can enforce individual rights, but without this power to take those abstract provisions to make legislation void. I think that we should have presumed something like that.
Mm-hmm.
I think this idea that if we interpretar a verdade,
Foi. Não, agora foi.
agora se desapertou.
If I'm not mistaken, this idea that fundamental rights should be applied directly.
Talvez não esteja.
Without the Congress like enforce it, I think this idea comes after World War II, right? If I'm not mistaken. So I'm not sure if Kelsen thought about specifically that. I think fundamental rights were bound to Congress. If I'm not mistaken.
Yes, I mean, he does have a more restricted view of what a constitutional court ought to do than we hold today. So, I mean, he's for instance, he's arguing against creating a constitutional court to which individuals can directly appeal, claiming that their rights have been violated. So he thinks that this would lead to such a flood of complaints that no courts could deal with it. And so he advises, on technical grounds at least, against embracing that sort of the possibility.
Yeah, and maybe the case is that just some authorities from the executive or the legislative branch can appeal to that constitutional court. Not the citizen will directly appeal to have the legislation declared void. Yeah? So it's not a way for the citizen to make his or her rights concretize and realize it. It's just to solve the conflict between the branches, the political branches.
Yeah.
Morreu.
Yeah, I think there was a question up there as well.
My question is whether my question is because the justice said that there's no distinction between legal and political decision. My problem is the courts do that distinction because they believe that they are taking decisions that are entirely legal.
Hmm.
Courts have this point of view of the job. And Professor Lucas showed us some texts on my law, and he said that the legitimacy of the court relies on this judiciary fiction that it's dealing only with law, not with politics.
Mm-hmm.
And there's other author, Brian Lyman, that said there's a contradiction because political decisions are being taken in this mass of the and we do not have this transparency that is so necessary to democracy. Because in democracy, we have the sense that with public power to make decisions in a transparent way. But the Supreme Court acts, the Constitutional Court's point very likely is that there's very few law in the American Constitution can be pointed to the moral beliefs of the judges, the political motivations. So my question is, isn't this lack of transparency of this game between, when we ignore this distinction between political decision and legal decision, are we passing through democracy?
Yes, I think the distinction between political and legal decisions, I guess it's very difficult because you could think of that difference in many different ways. And I guess what we see here is two quite radical ways to think about the distinction between legal and political decisions, right? So there's the Schmidt's way of thinking about the distinction, which clearly makes the category of legal decisions so narrow that it doesn't even apply to ordinary adjudication. So clearly in Schmidt's conception of how the distinction is to be drawn, something has gone wrong because we no longer have the ability to understand the operations or to describe the operations of the legal system in any plausible and descriptively adequate way. Now, on the other hand, I suppose Kelsen perhaps sometimes comes quite close to denying the distinction between legal and political decisions. And it may be that a plausible distinction for constitutional purposes must lie somewhere between these two extremes. And I guess that would take you into a complicated discussion within the context of a particular doctrinal tradition about how the distinction can usefully be drawn and what limitations that it might impose on the powers of courts would be appropriate in that context. And it seems to me that both Kelsen and Schmidt fly at a level of abstraction that is so high that their conceptions don't really engage with that issue. And that perhaps is a limitation of this debate.
So my question is, I'm studying some laws enacted in Brazil in the 20th century, and there was a debate in the Deportation Acts about enacted against the foreigners here in Brazil. And there was like a constitutional debate where our representative said that the Supreme Court shouldn't analyze the legitimacy of these acts, just the legality of these acts. And this made me think, seeing the Carl Schmitt theory of subsumption, how this would fit, like this would fit more in the Kelsen conception of what the court should do, like examine only the legal aspects, or insert more in the Schmitt view on the role of the court, examine the legitimacy, not only the legality of these acts.
Well, my sense is that perhaps Schmitt would have been the better reference point for making this argument. Of course, Schmitt distinguishes in his works between legality and legitimacy, and he thinks that all questions of legitimacy are always to be decided by political actors. So the question whether it is morally legitimate or politically legitimate to, say, expel foreigners is a decision that clearly he thinks should be taken by a political agency. And if a court can do nothing more than to subsume legal norms, then presumably that would leave them without an opportunity to stand in the way of such legislative action. Or perhaps, if we follow Schmitt all the way, there wouldn't even be a constitutional court that you might appeal to in order to throw a spanner into the works of such a statute. And so, yes, I think that given the political goals that you describe, people would probably be better off opting for Schmitt than for Kelsen as their constitutional theorists.
I would like to make a question. This question actually digs down a little bit on his argument about constitutional courts applying positive legislation. My question is, here in Brazil, we have like constitutional
Claims.
We got like constitutional claims that, for instance, in Brazil, there was something about strike. We didn't have a legislation on public officer strikes. And basically what the Constitutional Court did here was it applied the basic strike law with using an analogy. So this seems to me is pretty positive legislation, and it's not just procedural, it's pretty material legislation. And I would like to know if in Austria, in Kelsen's time, there was some constitutional dispositive that could lead to something like that, or not, or in other things. Kelsen used this argument just for Austria in that specific time, or he pretended it to be, or he wanted it to be more broad and apply to more legal systems.
I think he wanted it to be broad, so I think that he would have taken his argument to apply to any legal order which has a written constitution, but no sufficient guarantees of legality. And so, in that sense, the argument isn't meant to be specific to any particular jurisdiction. But yes, I mean, I think I agree with you. The case that you described would clearly have to be seen as an instance of positive legislation on the part of the Supreme Court or the Constitutional Court. And I suspect that Kelsen would have looked upon it with a degree of skepticism or disapproval, and that he would have argued that in taking decisions on the basis you describe, a court is showing insufficient restraint. But perhaps as a historical anecdote, so I said that Kelsen was a judge on the Austrian Supreme Court. And he had to step down from his role in the Austrian Supreme Court, I think in 1932, I believe, due to a decision that the Constitutional Court had taken and that led to a great political conflict in Austria, and that was about whether people who had been divorced could remarry. And the Catholic Church in Austria was opposed to the possibility of people who had been divorced to remarry, to have a civil marriage. But I think the city of Vienna in Austria wanted to introduce a rule that allowed people who had been divorced to remarry. And the Constitutional Court, under Kelsen's tutelage, I guess, or under his leadership, defended that rule and affirmed it. And some of Kelsen's own followers claimed that that was an act of positive legislation, and some of the Austrian followers of Kelsen, that is in conflict with his argument for constitutional review. So perhaps you can see that if Kelsen was untrue to his own principles, that this idea of negative legislation is very difficult to maintain.
Carlos. Pode falar, Carlos.
Just one moment. Okay. I would like Professor Vinks to elaborate a little bit on the idea of the counter-majoritarian role of constitutional courts, because you mentioned that this is only a secondary or ancillary concern of Kelsen's when he defends the existence of these courts. But here in Brazil, this counter-majoritarian role is very much emphasized in the works of our Supreme Court. So I would like you to elaborate a little bit on this question.
Yes, thank you so much. So I'm not sure I'm going to be able to really offer a good account of Kelsen's view about these matters, because I think that he's not giving us enough material or reflection on this issue to come up with a view that's defensible in a contemporary context. And perhaps that may be because the counter-majoritarian difficulty just didn't loom as large to people like Kelsen at the very beginning of this tradition of constitutional review that we are continuing today. But as I tried to point out in my presentation, so I think there is a real weakness and a lacuna here. Now, perhaps what might be said is that so if there is a counter-majoritarian difficulty, then it's tied for Kelsen not just or not exclusively to constitutional review, but also it's tied to the question whether there should be a formal constitution, so a constitution that protects certain norms, constitutional norms, against being repealed by ordinary statutes, or whether it is better to have what in the UK people call a political constitution, where any ordinary statutory enactment by implication repeals any constitutional norm that it conflicts with. So really you have to think about both questions together. Should there be a formal constitution? Should there be judicial enforcement of a formal constitution? And then the next step would be to think about, assuming that you believe that formal constitutionalism is a good idea and judicial enforcement is a good idea, what content should such a constitution have so as not to give rise to extreme forms of counter-majoritarian difficulty? And I think Kelsen's view about this question is that a constitution should be procedural for the most part. It should be concerned to lay down the rules of political decision-taking that allow for democratic self-government, and the role of a court should be limited or should be concentrated on defending the integrity of democratic procedures. And if you had a constitutional court that limits itself in such ways and a constitution that limits itself in such ways, then the counter-majoritarian difficulty would not be as pressing, or it would not arise with the same ferocity as it does today in most liberal democratic constitutions. And so I think Kelsen just didn't really foresee that this would be the path of development. And I think his overall political vision is in some sense quite different from what we have today.
Eduardo?
Hello, thank you, Professor, for this masterclass. The issue is the central role of constitutional court in Brazil society has become inevitable, whether due to the role signed by Brazilian constitution or the broad access to observe in Brazilian Supreme Court practice certain decisions declaring the inconstitutionality of an act or a practice that encountered challenges in securing its effectiveness. This can occasionally lead to an institutional deadlock, making it difficult to enforce some constitutional rights, often due to non-compliance by one of the branches of the government. So the question is how Kelsen or maybe Schmitt would address this conflict between powers when there is ambiguity about which entity holds the authority or the legitimacy over a particular norm, such as when legislative powers refuse, for instance, to comply with Supreme Court decisions.
Right. Well, I guess Schmitt's answer to that is probably quite simple, but at the same time unhelpful in the context of a modern constitutional system. So I take it Schmitt's answer would be that constitutional guardianship is exercised by a president or head of the executive using powers of emergency, which are not materially limited in any way, because the power to decide on the exception includes the power to suspend constitutional norms. And of course, if you have a political agent that can play that role or does play that role, then that there is in the end, no room for conflicts of authority to arise. And I think Schmitt was attracted to the solution for Hobbesian reasons, perhaps in part. So he was driven, at least in part, by the fear that there might be conflicts of competence in a legal constitution that turn out in the end to lead to deadlock, and then you need a sovereign authority who can always intervene and cut the Gordian knot. But obviously this comes at a very, very heavy political price that we would not condone today. I think as far as Kelsen is concerned, obviously the answer would be that the Constitutional Court is going to have the last word in resolving such questions. But as I try to suggest in my presentation, it may be that Kelsen's argument here carries the weakness that he doesn't see that a constitutional court might itself become one of the organs that finds itself in conflict with other organs. I don't think that he has thought through the question what to do in that kind of situation.
Thank you very much.
You know, to make our point? No? Anyone else? So, thank you, Lars. Tomorrow we will have Professor Alexandre Travessoni from the Federal University of Minas Gerais also to comment upon this debate between Dworkin and Waldron, which is